be going too far, in my judgment, to adopt the second course. It would indeed be judicial legislation to read a section conferring discretionary powers on the court as abrogating a common law right. I am not prepared to go that far in an attempt to make sense. If one had to go that far, then it would be for the legislature, not the courts, to make that step. My lords, this is a clear authority for the principle that to reinterpret section 36 as the appellants have contended, in the views of the judiciary, although these views are not binding upon the Supreme Court, they do lend strong support to my submission that to reinterpret section 36 would be judicial legislation and be contrary to the intentions of Parliament. Lord Justice Chadwick also agreed with this view, as did Lord Justice Gough in Western Bank. Lord Justice Chadwick says at tab 3, my lords, I do apologise for running you around the ring. The second paragraph on the bottom, my lord, halfway down, an English judge. And this is at page 14 of the exam. An English judge is not to indulge in judicial legislation. Before he can apply words into an act, the statutory intention must be plain and the assertion not too big, or too much at variance with the language in fact used by the legislature.
Apologies, I think we've lost it because the tabs have come off.
Oh.
So we're on page, apologies.
Page 14 of the Repage Act report, my lord, which is the first report in the bundle. Shall I continue, my lord?
That's it, there we go.
An English judge is not to indulge in judicial legislation. Before he can apply words into an act, the statutory intention must be plain and the insertion not too big, or too much at variance with the language in fact used by the legislature. The case provides no support for a contention that Parliament must have intended that the mortgagee's right to possession should be exercised with only the assistance of the court. As this clearly shows, my lord, several members of the judiciary, including quite high-ranking members of the Court of Appeal, considered that the reinterpretation as submitted by my learned friends opposite would be contrary to the intentions of Parliament and be going too far outside the ambit of the judiciary. If my lords have no further questions on this point, I will come on to the third submission.
Yeah, thank you.
My lords, you have been presented in this case with many eloquent and emphatic arguments and reasons to overrule the decision of Repage Act and Barclays Bank and reinterpret section 36 in order to effect the result where mortgagees would always have to apply for possession through the courts, and so allow mortgage laws of limited offences offered by section 36 of the Administration of Justice Act in every case. It is our submission that there are many reasons why this should not be the case. There are, first of all, limitations upon the right of the mortgagee. I based this submission on the judgment of Lord Justice Henry at page 287 of the report, Repage Act report, which is tab number 6. However, due to time concerns, I will not be reading this out. Other limitations, my lord, which I shall run through briefly, are the fact that possession must be obtained peaceably. Lord Justice Chadwick refers to this in Repage Act and states that the reason for this is mainly because of the section 6 of the Criminal Law in 1977, which says that to obtain possession otherwise would be contrary to the will be to incur criminal liability. As I run out of time, my lords, I shall hand over to my learned friend, Mr. J. Hay.
Thank you.
If you have any other questions.
If it pleases your lordships, my name is Mr. Hay, and I shall continue with the respondents' submissions based on the second round of appeal. My lords, it is our submission not only is the case of Repage Act rightly decided, but also that under section 36 of the Administration of Justice Act 1970, as amended by section 8 of the Administration of Justice Act 1973, there is no power to suspend the repossession of a property that has already been concluded. And therefore, the issue of whether or not Mr. Merchant is able to repay the arrears within a reasonable time does not apply. Even if there is found to be such a provision, and we do not concede that there is, then it would still not apply in this case, as immediate repossession would have been ordered anyway, on the ground that the appellant was unable to make payments of arrears within a reasonable period. My lords, section 36 of the Administration of Justice Act states that the court has the power to delay giving a mortgagee possession of the mortgage property, so as to allow the mortgager a reasonable time to pay any sums under the mortgage. The Act does not lay down a time limit, and the Court of Appeal decision in the case of Gloucester Building Society in Norgate contemplates that a reasonable period for repayment may be the whole of the remaining mortgage term. My lords, we find Norgan at tab L of the...
That's fine. Keep carrying.
We submit that this by no means creates a general rule, but rather a starting point, and is open to the discretion of the court to determine the period of time based on the individual facts of the case. In Norgan, my lords, Lord Justice Evans summarises 8 relevant considerations regarding what their lordships deemed a reasonable period, which he listed at points A to H at page 357 of the case report, or at yellow tab 11. His last paragraph, my lords. If it pleases your lordships, I will include in my submissions Lord Justice Evans' 8 considerations as I proceed. Point A. How much can the borrower reasonably afford to pay, both now and in the future? With regard to this consideration, my lords, we would submit that we are not blessed with sufficient facts before us to ascertain the amount the appellant can afford to pay, both presently and in the future. Point B. If the borrower has temporary difficulty in meeting his obligations, how long is the difficulty likely to last? Once again, my lords, we cannot know this, unfortunately. Point C. What was the reason for the arrears which have accumulated? And point D. How much remains of the original term? The arrears, my lords, have accumulated, pardon me, because the appellant found it virtually impossible to meet his mortgage repayments of £2,200 per calendar month on his average annual income of £40,000, and there are still 17 years left on the original term of the mortgage. And, my lords, this monthly payment will increase to £2,329.42 when the existing arrears are added. Point E. What are the relevant contractual terms, and what type of mortgage is it? That is, when is the principal due to be repaid? Again, my lords, unfortunately, there are insufficient facts before us. Point F. Is it a case of whether court should exercise its power to disregard accelerated payment provisions? We are unaware whether there are any accelerated payment provisions, and it seems unlikely that the appellant would be able to meet these in any case. Point G. Is it reasonable to expect the lender, in the circumstances of the particular case, to recoup the arrears of interest, 1, over the whole of the original term, or 2, within a shorter period, or even 3, within a longer period, that is, by extending the repayment period? Is it reasonable to expect the lender to capitalise the interest or not? The question as to a reasonable period and implying a term which extends the repayment period will be addressed later in my submissions, my lords. And finally, point H. Are there any reasons affecting the security which should influence the length of the period of payment? Once again, my lords, there are insufficient facts before us to ascertain whether or not there is anything that might affect the security of the case. My lords, it is for the appellant to prove that he is able to pay the arrears within a reasonable time. Therefore, it's for the appellant to show how much he can afford to pay, both now and in the future, how long the difficulties are likely to last, and the reasons for the accumulated arrears. It is not for the respondent to prove these points, and the appellant hasn't benefited the court with them. It follows, therefore, that in the case before the court, there is insufficient evidence to demonstrate that the appellant's debts will be paid within a reasonable time. And due to this lack of evidence, my lords, it is our submission that the court would have to order immediate possession anyway, as Judge Duke stated at first instance. Indeed, my lords, this was also the case in the 2000 unreported case of Halifax and Godalming that you may find at point P, tab P of the bundle. In the facts provided in the present case, there is no suggestion that the appellant has a steady source of income, or how much he earned from playing the lead role in his Italian film. And for these reasons, how long it would take for the arrears to be repaid is far too uncertain. It is our submission that the learned judge at first instance, and indeed the Court of Appeal, must have taken Lord Justice Evans's 8 considerations into account, with the relevant evidence before him, and still considered an immediate possession order would have been ordered. Indeed, my lords, the respondent cannot wait forever for its repayment, and the fact that the appellant currently has little income means that he is unlikely to be able to repay the mortgage full stop. It is the right of the mortgagee, when a mortgager defaults on the mortgage, to take peaceful possession of the property and to sell in order to regain their money. Essentially, my lords, our point is that applying Norgan would create huge injustices to mortgagees. If it were to become a general rule that the mortgager had the entire term of the mortgage to pay arrears, then mortgagees would be most reluctant to lend money. And as our learned friends opposite have insisted, we would insist the complete opposite, in that maintaining this current balance of powers between the mortgagee, or rights rather, between the mortgagee and the mortgager, would add to a more stable economic climate. Furthermore, my lords, to force mortgagees to seek court orders before attempting to exercise their right to possession would make a mockery of the basic and fundamental rules of our contract law. With regard to what constitutes a reasonable period of time, the 1999 case of Bristol and West Building Society in Ellis, found in volume 29 of the Housing Law Report at page 282, or tab N of our bundle, did not apply Norgan and held that 3 to 5 years was not a reasonable time for the bank to await payment and ordered immediate possession. In conclusion of this point, my lords, the respondents submit that the appellant would need to be earning over £40,000 per year to be able to meet his terms of the mortgage agreement and pay his arrears. The facts before the court are too uncertain whether or not the appellant has earned the appropriate sum of money, and this unfortunate lack of evidence means that the court cannot determine whether Mr. Merchant may pay the arrears within a reasonable period. Thus, unless evidence to the contrary exists, the court would have to order immediate possession anyway. We finally submit that although the case of Norgan stated at consideration G3 of my earlier submissions, that it might be reasonable to expect the lender to recoup the arrears of interest by extending the repayment period. To impose such a term would make a serious inroad towards the doctrine of freedom of contract, whereby individuals should be free to bargain amongst themselves. And the imposition of such a term would tip the balance too far in favour of the mortgagor. And in any sense, as a respondent has already repossessed the strap of property, Lord Justice Evans' requirements are wholly irrelevant. My lords, in conclusion of the respondent's submissions, in reference to the speech of my learned colleague Mr. Small, section 36 cannot apply, as according to the exact wording of the section, powers under subsection 2 could only arise in a situation where an action is brought before the court. Secondly, this was a decision reached in the page that section 36 cannot bear any other interpretation, and it was correctly decided, we submit. Thirdly, for the policy reasons given by my learned friend, an attempt to reinterpret section 36 and the page would alter the balance of interests between lenders and borrowers, and accordingly, such a decision is best left to Parliament. With regard to my submission, Your Lordships, I urge you to uphold the decision of Judge Duke in first instance, in deeming that section 36 of the Administration of Justice Act does not permit the court to stop possession by the mortgagee, and the repossession has already been concluded. And indeed, there are no grounds under the aforementioned Act, or any other statute or rule, for the court to imply a term extending the repayment of arrears before the contractually agreed term of the mortgage, as it would be unreasonable to do so. Unless I can assist Your Lordships any further, that concludes the respondent case.
I have one question on one of your final submissions in relation to section 36(2). Can you just explain to the court why you believe that this is not relevant where, I think your point is where the sale has already been concluded?
Indeed, my lord. My lord, in answer I would submit that The reason Section 36(2) does not apply is because the entire intention of the Administration of Justice Act is for when an order for possession has been applied at the court. That is our submission on the matter, my Lord.
My Lord, in regards to that question, if it pleases your Lordship, we'd like to both respond to that question as well. The first part would be that in deciding the Rutledge case, in regards to Section 36, Parliament's intentions were unsure, and it was stated at the end of the case that Parliament's intentions were unsure in regards to Section 36, and later on it has been corrected in the Mortgage Repossession Act of 2010. And if you'd like to respond into subsection 2 as well in regards to Section 36.
My Lord, we realise that there is a small difficulty suspending a court order for a repossession that has already taken place. But our point is that we should have been able to rely on Section 36. We did not get the fair trial at the start in order to allow us to raise the defence. And my Lord, my learned opposition are correct in saying when they accuse us of trying to effect the balance of power between the mortgage union and the mortgager. We are thinking that the current balance of power between the mortgagee and the mortgager is so far in favour of the mortgagee that our one defence rests solely on their actions. We are merely requesting my Lords to rectify this injustice and create an even-handed equilibrium and correct the scales of justice.